Hello, and today on Tree Law TV, I am talking about Japanese knotweed. I've got a new case law story to tell you, which is one of the most recent cases arising from Japanese knotweed. That's a case from the Cardiff court, and it is Williams and Waistell versus Network Rail that was heard back in 2017, 2018. So Williams and Waistell were both homeowners, owned properties adjacent to Network Rail's railway line, and they claimed that the presence of Japanese knotweed on Network Rail's land had actually reduced the value of their properties. So they claimed against Network Rail to recover that reduction in value. The judge at the original case in Cardiff awarded the claimants damages to compensate them for the loss of value, and Network Rail appealed that decision to the Court of Appeal. So off it went to the Court of Appeal. Whilst the Court of Appeal didn't actually change the outcome of the case, they did change the reasoning behind the decision. So what the court said was that if there is a claim by claimants in nuisance, you cannot recover monetary damages, for what's called a pure economic loss. So the lawyers out there will be well aware of that. It's basically a rule that says in civil law, claimants cannot recover money to compensate them for just a monetary loss. There has to be an associated loss or damage as a result. However, whilst that is the law, the Court of Appeal did award the claimants monetary damages, and it related back very similarly to the tree root subsidence case of Delaware Mansions, which I spoke about a couple of weeks ago, and talking about encroachment. So the law of nuisance and encroachment of roots, in this case Japanese knotweed rhizomes, so the encroachment of rhizomes from one person's land to the other. So what the Court of Appeal judge said was, because there had been an encroachment of these Japanese knotweed rhizomes from the defendant's land to the claimant's land, then that encroachment was enough to satisfy the claim in nuisance and was enough for the claimants to be able to be awarded monetary damages. So that was the Court of Appeal decision in 2018, which caused some concern, obviously, for the likes of Network Rail or large landowners who own land on which they are aware that there is a presence of Japanese knotweed. Following that then has come some relatively new RICS guidance. So this is an updated set of guidance which came out in March 2022, so relatively recent, and it talks about the effect of the presence of Japanese knotweed on residential property values, because the reasoning behind Japanese knotweed affecting property values is because it affects the mortgageability of properties, and obviously if you can't secure a mortgage against a property, then its value is going to drop because it will only be open for purchase to cash buyers. So there's that RICS guidance which has come, which should ultimately make it easier to buy and sell property. It gives some guidance on categories of damage being caused by Japanese knotweed and the ways in which investigations should be carried out and how Japanese knotweed should be removed. Referring back to the Environmental Protection Act, Japanese knotweed is classed as hazardous or controlled waste, so it has to be removed from sites by registered contractors in a very particular way, but again with an eye on environmental obligations and the carbon footprint of the enormity of some of the extent of work that could be carried out here. The guidance makes it clear that the minimum work should be done at all times, and that the focus shouldn't always be on, well, it shouldn't be on eradication of Japanese knotweed. It should be on control to keep things reasonable. So there we go, back to the word reasonable, which seems to underpin everything in these cases in nuisance and negligence. Anyway, Japanese knotweed, hope you enjoyed.